Hello, my name is Erica Staub-Absher, and I'm the director of Hope Center here in Rice County. Hope Center is an advocacy organization that works with domestic violence and sexual assault victims throughout the entire process. Today, we're going to learn about the complexities and all of the different agencies that may or may not be involved in your case, and we wanted to let you know a little bit more about how we work together. Now, Hope Center itself is a domestic violence sexual assault nonprofit, and we work very closely with these agencies, but we aren't part of these agencies. And we work to make sure that everybody's voice is heard, particularly the victim's voice, and that we can work together to make your process as smooth as possible. One of the things that advocates do is just to kind of explain what's happening next. Where do we go from here? From the first initial phone call to law enforcement, after they arrive on the scene, you're connected with an advocate, and that advocate will walk through the entire process. Together, we're going to make sure that you know what's coming next and know what different agencies are working with you and what we can do to make sure that you get the services and anything that you need. So one of the questions we get a lot is, what happens if there's children involved? And sometimes that might go to what we usually call child protection, but child and family services. And one of the pieces is people think, oh, child and family services are going to take my children. And that's not the case. And so one of the things that we do is we help work with child and family services to make sure that you are able to protect your kids. And really, that's the goal of all of us, is to make sure that both you and your children are protected. And so Child and Family Services is able to connect you with resources. Sometimes they have different availabilities for pots of funding that you're able to use to make those next steps and those new transitions to a safer, violence-free life. And so we want to make sure that you're connected with every agency that might be able to help you move forward.
Hi, my name is Wendy Murphy. I'm the Chief Assistant Rice County Attorney, and today I'm going to talk about the process that happens when someone is arrested and charged with a domestic violence case. The first step is that someone has called the police. They've either called 911, a neighbor has called 911, or a child has called 911, and the police will respond. Once dispatch has told the officers to respond to the address, the police will get there and make a decision whether somebody will be arrested. If the perpetrator, which we will call the defendant, is arrested at the scene for committing domestic violence, the defendant will be taken from that location and brought to the Rice County Jail. Once they are there at the Rice County Jail, they will be charged with an offense. That means the police officer will tell the jail staff what offense the defendant committed. And normally that's going to be something like a domestic assault, domestic strangulation, threats of violence, DANCO, or domestic abuse no contact order violation, or an OFP violation, or a harassment restraining order violation. Once the defendant is booked into the jail, he will no longer have contact with the police, and he will wait there until the first appearance in front of a judge. That can take anywhere between 24 and 48 hours. During that time, the police will send the reports to a prosecutor. Like me, I am a prosecutor. Once I receive those reports, I will review them and determine what are the appropriate charges. Even though the police have made a charging decision when they bring someone to jail, ultimately it's up to the prosecutor to determine the appropriate charges. It is important to understand that at this point, the victim of any crime does not have the opportunity or the responsibility to make a charging decision. It is all up to the prosecutor. Once a prosecutor has decided to charge a case, they will generate something that's called a complaint. And really what a complaint is a summary of the facts that occurred and why the prosecutor feels a person should be charged with those charges. Once the complaint is signed by a judge, a court hearing called an arraignment or a first appearance will be scheduled while the defendant is still in custody. The defendant will be brought from the jail to the courthouse. At that hearing, The defendant will be able to apply for a court-appointed attorney, have a hired attorney appear, and the only thing that is discussed at that hearing is to make sure the defendant understands what he has been charged with, what rights, constitutional rights he has, and what, if any, monetary bail or conditions of release will be imposed. Present at that hearing will be the prosecutor, a defense attorney, and the judge. Conditions of release or bail are conditions or monetary amounts that a defendant must comply with or provide in order to get out of jail. What determines the appropriate conditions and monetary amount is a judge's concern about public safety, victim safety, or the defendant's history for failing to appear. In domestic violence cases, that generally means we are going to have conditions of release that protect the victim's family, such as no contact orders, prohibiting somebody from being at a place of work or a school or their residence or their family member's residence. We will sometimes have a domestic abuse no contact order, which again is just an order that says the defendant cannot have any contact with the victim. If there are chemical dependency issues, we can ask for no possession, no use, and testing requirement. And in certain circumstances, we can have a defendant put on GPS monitoring. Very often, victims are frustrated because from the time that a 911 call is made to that first appearance or arraignment hearing, there isn't a lot in the process that allows a victim to give input. So there's often times that victims want to let a prosecutor or the court know of certain things, and there really isn't a way to do that. The one option that a victim has is to communicate with an advocate from Hope Center or communicate with the Rice County Attorney's Office Crime Victim Liaison. Those are two entities a victim can contact while a defendant is in custody to provide his or her input on what they want to see happen as conditions of release. Once the first appearance or arraignment hearing has ended, the judge will give the defendant and his attorney a date to return for the next hearing. This becomes the longest part of the case. Many times there can be months between hearings, and it can be very frustrating for a victim because it feels like there isn't a lot of work being done on a specific case. But during that time, the prosecutor is obtaining all of the evidence, including the electronic recordings, and is working with the victim to get their input, and is talking with the defense attorney to see if there are ways that the case can be resolved. If a defendant does not want to plead guilty and agree to an offer, a plea agreement that is made by the prosecutor, unfortunately what happens then is the case will get set for a jury trial. Sometimes a jury trial can be as far as a year from the original offense date, up to a year and a half or even 2 years. It is a very frustrating process, and it is not something that is victim-centered. However, during that time, it is very beneficial for a victim if they continue to engage with advocacy services or crime victim liaison services. Ultimately, if the case does go to trial, the state will be calling the victim. The prosecutor will be calling the victim to testify. And calling the victim to testify means we will be sending you a subpoena, and we can personally serve you with that subpoena. A subpoena is a court order, and it requires you, if you are the recipient of a subpoena, to come to court on that day because a judge has ordered you to do it. And if you do not comply with that subpoena, the state is able to get an arrest warrant for you. It is not something that we like to do, but very often defendants will tell victims that if they just don't appear for the jury trial, the case will be dismissed. If we have to go to trial and if a victim must testify, there are a lot of resources, and we will spend as much time as the victim needs to work with you to get the victim used to seeing what the courtroom looks like, expectations of what it will be like to give your testimony, and allow you to have a support person during the trial. That was just a quick summary of what happens in the criminal justice system when a person is charged with a domestic violence.
Hello, I'm Sarah Palm from Southern Minnesota Regional Legal Services. Abuse or a history of abuse can have an impact on custody. Sometimes people are victimized by family violence, but they think that because they haven't been physically wounded or reported the violence, that they aren't real victims. These people may go without legal help or may not take advantage of community resources such as the Hope Center. In Minnesota, when parents are not married, the mother has sole legal and sole physical custody of their children. Married couples share legal and physical custody. Often, the next area a person faces abuse in is the family court system, and that could be an order for protection case, a divorce case, or a custody case. Often, too, outside the family court system, an abuser might try to keep children away from the victim, and this does require a certain knowledge and understanding of the laws to get their children returned. A person subjected to financial control may feel even more disadvantaged or victimized by the legal process, and this is where community resources become even more important. An advocate can connect a victim to help that is available, whether that be legal assistance or advice from Southern Minnesota Regional Legal Services, or more general legal information through lawhelpmn.org, or court documents that can be found on the Minnesota Courts website. Information and legal advice can help level the playing field and give a victim back some power and control.
Hi, my name is Anika Richner and I work at Community Action Center. CAC is a local human service nonprofit organization here to help with lots of basic needs, including emergency food, housing, employment, help through the recovery process, and so much more. More importantly, our job at CAC is to help people feel safe and welcome and dignified. We know that many people come to us who are scared. It's hard to ask for help, and we're here to help you navigate through the hardest times in life. We have resource centers and food shelves located in Northfield and Faribault. There's no appointment needed. Come anytime during our hours, give us a call, or check us out online. You're not alone. We're here to help.
So hopefully now you know a little bit more about the process and it's a little less intimidating. There's still a lot of things that you might have questions about, and that's why we're all here. We all want to make sure that you have everything you need to start your violence-free life, and just remember that that advocate is here to walk through the entire process with you. So if you have any questions, if you need anything further, please don't hesitate to call us. We have a safe line number, we have our main line number. Any one of the people mentioned in this video would be more than happy to make sure that you get to the right place so that you can live free of violence.